Yeah, the idea was try and contextualise.
You're being objective, I understand.
It is, well, yes, thank you.
Okay. As was Mr. Carey, hasn't he?
I'm sure, yes.
Thank you. Okay. Can I ask you, I'm going to ask you first about road safety. Mm-hmm. And this, a slightly different topic order, but in those three main topics. The first thing I wanted to deal with was just the general policy context, which you helpfully set out in your proof. Can you go, please, to page 14 in your proof, your main proof? Paragraph 4.5.2.
Yes, here we are.
And you set out there paragraph 114 of the MPPF, and which says, in assessing sites that may be allocated for development in plans or specific applications for development, pausing there, we're agreed that's the applicable part here. We are assessing a site with a specific application for development.
We are.
Yep. It should be ensured that, and then 4 points, the second one of which is relevant to this first topic area, safe and suitable access to the site can be achieved for all users. Yep.
Correct.
So safe access is an essential requirement of compliance with paragraph 114. Thank you. Then we see in the following paragraph, paragraph 115, development should only be prevented or refused on highways grounds if there would be an unacceptable impact on highway safety or residual cumulative impacts on the road network would be severe. Again, for the purposes of this part of my cross-examination, and indeed for the whole case, because we're not now asserting a severe impact on the road network, the key issue is whether or not there would be an unacceptable impact on highway safety. If there wouldn't be, then it shouldn't be refused. If there would be, it can be refused.
It doesn't answer the question if it's refused or not refused, but certainly it's a material consideration under para 115.
But it says that it should only be refused on either of those two grounds, doesn't it? On highways grounds. Obviously there could be other issues.
Yes.
Okay. Equally, if we go to the development plan context, page 11, so going back in your proof a few pages, to policy S4, paragraph 4.21, we see there planning permission will be granted for development. I'm just reading the last sentence of the main paragraph. If R, we know there are other criteria, it will have safe access and won't generate traffic of a type or amount which cumulatively would cause severe impacts on the transport network or require improvements or alterations to rural roads which could be detrimental to their character. Leaving apart the last bit, that largely mirrors, it was adopted after the MPPF was published. It's clearly intended to mirror or reflect the MPPF test in paragraph 115, isn't it?
I can't speak accurately as to the intention of the policy, only that it exists, and obviously we've referred to it.
Okay. Can I ask you this then? Do you agree that if the access isn't safe, there would be conflict with policy S4 criterion R?
Yes, the policy, the R element of that policy seeks to ensure safe access.
Thank you. Now, the nub of the dispute, or the central part of it, you set out at paragraph 516, page 20. This is your conclusion on road safety. It's therefore considered the proposed access arrangements onto Wyston Road are entirely compliant with policy S4 and HC19 of the local plan. And it's also noted that matters pertaining to suitable access and safety aren't raised as a point of contention in the statement of case from the council, or that was your view, which would also suggest as agreement there is no material considerations to suggest proposals would be considered unsafe. So let me break it down into your position, leaving aside the commentary on the council's position, which is more contentious. You say the proposed access arrangement complies with S4 and HC19. So you say it's, in particular, you say it's safe. And you also go on to say your position, which you thought there might be agreement with, is that there is no material consideration to suggest that the arrangements are unsafe.
Yes.
Okay, thank you. Now, we have, however, two road safety audits. One, as you said, commissioned by the appellant, by Midland Road Safety, in your Appendix B. The other by Amy, conducted by Amy on behalf of the local planning authority. I'm going to start with the one that was commissioned by the appellant. Again, it's understood that this was commissioned after the decision to refuse planning permission by the planning authority.
That's correct.
Yeah. And I am assuming it was done for a reason.
It was.
And would it be fair to assume that you will have advised your client on this issue?
Yes.
Okay. So would it be fair to assume that it was done on advice from you?
Yes.
Thank you. And you've included it and referred to it in your evidence, and indeed we've in both written and oral, and we're spending a long time on it, and we'll spend some more time on it. And you wouldn't have done either of those things, i.e. advised that a road safety audit should be carried out, or referred to it, put it in your evidence and referred to it, unless you considered it to be material to the issues which the inspector has to determine. You wouldn't be putting immaterial or irrelevant documents before the inspector.
I wouldn't phrase it like that personally. The main driving factor for commissioning and including the RSA was in order to address the comments raised as part of the refusal. So obviously we got through the development of the application, the submission and the engagement with Derbyshire County Council Highways. And during those discussions, we did discuss highway safety. We provided additional evidence, and at no point did Derbyshire County Council request the commissioning of a road safety audit. So, for the purposes of the Highway Authority's decision-making, it would not be considered a material impact requirement because it was not necessary or requested.
No, my question is different. I'm not saying it was a requirement of the Highway Authority. They clearly didn't require it, or there's no evidence that they required it. My point is different, is you would not have advised your client to commission the audit unless, as you said, and you agreed, unless there was some reason for that.
Yes.
And my point is, after having done that, you wouldn't have put it in front of the inspector unless you thought it was material to the issues in this inquiry.
I included it because it was informative in addressing some of the comments that have been raised as part of the expert evidence that's been provided for us. The same rationale as for including the modelling of the five-arm junction. Not that we consider it to be material, but helpful in the points of this inquiry.
Well, maybe I'll use a different word for material. Material is material consideration and relevant consideration are usually taken as synonyms.
Okay.
So when I say that's certainly what I mean. So it is, I want to put it is a relevant consideration because it goes to the issue of road safety raised by the first reason for refusal.
Yes, I can. Yeah.
And the reason it is relevant is that it's talking about the MSR audit, is that there is a view expressed by a team who are qualified, experienced, and therefore competent to express, to give a view, or to carry out a risk-based assessment on the safety of this junction. Okay. So it is a relevant consideration that the inspector, put it like this, has to take into account.
The terminology is tricky. However, I think it's an important part of the decision-making process in front of us here. Yeah.
Okay, thank you. Can I just go through the requirements for the RSA team, which are in GG 119, inquiry document 5, on page 15. I'm not going to go through all of them, but the ones which are pertinent.
Okay, yep.
The first one you've referred to in your rebuttal, which is at paragraph or section 3.5, a specialist advisor should be independent of the RSA team. And sorry, I beg your pardon.
Sorry, can I just, is it rebuttal paragraph 3.5?
Yeah.
What's that?
Sorry, I may have got the wrong part of it. It's
3.5 in the RSA guidance documents.
Is it that paragraph?
so it's just bear with me 1 second. I think it is. Yeah. So I think the way you quoted it in your proof, it's just there's a slight difference between the way you've quoted it and the way it's set out there. So in your proof or rebuttal, it says the RSA team shall be independent from the highway scheme conception, design, construction, and operation.
So where are you going in the rebuttal proof?
Exactly the part that you took me to before. So it's, sorry, I beg your pardon, I had got it slightly wrong. It's 3.3, not 3.5. That's why I was just getting confused. It was 3.5 is specialist advisors. So the relevant part, the RSA team shall be independent from the highway scheme conception, design and construction and operation, yeah? That's the first requirement, the requirement of independence from the design, construction, etc. teams.
I'm really sorry, Mr. Johnson.
But I can't follow the referencing. Is there a paragraph in the rebuttal?
There is the same one that I've said, I think, a couple of times now, 3.3. No, sorry, 3.3 in the guidance, sorry.
Yeah, well, that's...
Well, it's, if I could move on with it, and it's in Mr...
I'm sorry, it is important that I can follow the referencing so that if I need to re-examine, I can.
It's in 2.4 of his rebuttal. With respect, I'm afraid it's not my job to help you with your re-examination. Right, so Mr. Price, going back to the guidance itself, question, third or fourth down, I'm asking now. The first requirement is the team is independent from those who were involved in the conception, design, construction and operation.
Correct.
Right. And that means that you're disqualified for one in being a member of the RSA team because you're involved in the design. You're the design organisation. Okay. And the reason for that, it isn't set out, but is, I think, self-evident, which is you can't mark your own homework.
Yep.
Okay. The one thing I do want to pick up, though, is in your evidence in chief, you said, you referred to what you thought or see as the major difference between the Midland Road Safety RSA and the AMI RSA, which was that you said that, which is to do with their view about the achievability of the visibility displays. The way you read the AMI report is that they weren't confident or satisfied that you could achieve the visibility displays.
That was my interpretation, yes.
But the MSR were, was the difference you highlighted. Is that correct?
MSR took the drawings, Midlands Road Safety took the drawings that we provided as part of the brief, if you like, the commission to undertake the RSA, and within their assessment they say, based on the visibility drawings provided, we have undertaken our assessment.
Yeah, I disagree with that, but I'll come back to that. Just the way you put it in chief, though, was that you had briefed them that the visibility requirements could be achieved. Did you misspeak, or did I mishear that? Because did you actually tell them that we can achieve the visibility display requirements?
We did not talk specifically about what can or cannot be achieved. However, we did provide the drawings and the calculations that we used in order to prepare the drawings so that they can determine themselves whether visibility...
You understand the difference, so you shouldn't tell them it's for them to...
Absolutely, yes. We provided them the same body of evidence that we used to do our calculations.
Okay, so either I misheard or you misspoke if what you said was that you briefed them that it was achieved.
No. There is, as you know, we spoke previously with regards to the AMI situation, a degree of separation that we like to enforce with regards to commissioning road safety audits as well, i.e. a pack is handed over and they work with that.
Okay. So going through the other requirements, 3.8 in GG 119, the team have to demonstrate competency.
Yes.
Yeah. And over the page, we see sorry, it's not over the page in this version of this. Sorry, so it's note 1. No, it is over the page, I beg your pardon. So go over the page, there's then a table 3.82, the following page 17 it must be. Note 1, whilst it's not intended the RSA team have extensive detailed design knowledge, it's important to include members with experience or training in road design. So it's not a requirement, but it's important. They have experience in road design.
This is note 1 on page
17.
17, yes.
So that's important that it's important that the team has experience of road design.
Yes.
And presumably the people that you instructed did?
We believe they did, yes. Yeah.
Okay. And finally, 3.9, at least one individual within the team undertaking RSA must hold a certificate of competency in RSA. And I think it's correct, isn't it? I think that is the case in both road safety audit teams.
I believe it would be.
Yeah. Okay. Do you have you don't list one of those certificates as in your qualifications. Do you have such a certificate?
I'm not a qualified RSA undertaker.
Okay, thank you. Could you go back in the guidance, please, to page 5? Just to see why one would do RSA in a situation like this, where you were evidently satisfied that you can achieve manual for streets requirements in terms of visibility. Under these, from the 2nd to 5th, I think, paragraphs under background, we see that even with the careful application of design standards by competent professionals, the design process will not remove all hazards for road users. The road safety audit process, as set out in this document, helps manage the interaction of different design requirements for highway schemes. The objective is to identify aspects of engineering interventions that could give rise to road safety problems and suggest modifications that could improve road safety. It's important that it's not intended to be a technical check of compliance with design requirements. And finally, although road safety is always been considered during design, road safety audits exist for a number of years to provide an independent check that design characteristics don't contribute to collisions and/or incidents on highway schemes. And what that is saying, is it not, is that the point of 2 points of road safety, or two major purposes. One is, even if you're a competent professional and have achieved your design requirements according to relevant standards, there can still be road safety hazards, for example, because of the interaction of different design requirements. So it's to get an overview of road safety rather than just simply apply the technical standards, because applying the technical standards doesn't necessarily guarantee by itself there won't be a road safety problem.
I'd agree, yes.
Yeah. And the second thing is to have an independent check. Those are the two main purposes of it. Good, thank you. And so it follows in this case, doesn't it? You're not suggesting to the inspector, well, look, because it might have been taken at that if you read bits of your evidence. You're not saying, look, the be-all and end-all of this is, I have demonstrated, and Mr. Carey isn't disputing, that we can achieve the required visibility in accordance with manual streets, and therefore there can't be a problem. You're not saying that.
Well, the material point of achievable visibility, i.e. the finite confines, my impression, having read the evidence and rebuttal documents, would actually strongly suggest that there is contention around whether achievable visibility it can be reached or not. I think my takeaway points, apologies to continue,
no, go ahead.
The takeaway points I've had through the inquiry over the past day and a half is perhaps, a softening of that position and acceptance that the physical requirements in regards to visibility are achievable.
I think what is being accepted is there's no dispute that you've calculated them correctly.
Okay.
And there is no positive contention being made that they're not achievable.
Sorry, apologies. By that, do you mean they are achievable?
No, so there's no positive contention. I'm trying to be cautious about it because the inspector will have a note. So you're expressing a different view. So what we are saying is we proceed on the basis that you calculated them correctly.
Okay. Yes.
And they are achievable. Okay.
Okay.
Certainly for the purpose of my question.
Okay. Sure.
So let's say that's right. What I'm just seeking to understand now, before I go into the next set of questions, is this: you're not saying, if that's the case, if it is accepted that I've calculated them correctly, and that they are achievable, that ipso facto means that there can't be a road safety problem at this junction. Because, or are you saying that?
No. I think I would agree with the statement that road safety in the round is more than visibility displays.
Okay, thank you. And that's what the guidance is saying there, isn't it? Even if you achieve the standards, for example, in relation to visibility stays, there still might be a road safety problem. So there's a point in doing road safety audit because just achieving the standards might not have picked it up. Okay, right. And both the Midland Road Safety team and the AMI team identify road safety problems, don't they?
They do.
Okay. Notwithstanding, now let's deal with the question of whether they do it on a different basis, because Midland Road Safety accept you have calculated correctly and can achieve the required visibility displays, and Amy don't. You go to, first of all, or it might not have to do it with Midland Road Safety. We accept that they do. Your case is that they say, I think they say explicitly, don't they? Even with the, in fact, let's go to it, so there's no doubt about it. So if you go in your appendices, please, to Appendix A.
Yep.
Where they identify the problem on the northbound approach to the site. They say they summarise its nature as the lack of awareness of the junction risks, risk junction pull-out collisions. And then they say this: whilst visibility of and from the access is shown as being achievable within the drawings provided. And you read that, and I think I read that as well as saying, well, the drawings show that the required visibility can be achieved, and so we take that, we operate on that assumption, yeah, okay. And then they go and say, nevertheless, they don't use the word nevertheless, but it's implicit there. There is a concern the access is within the area of national speed limit road, and some drivers will therefore not be expecting a significant residential access junction, especially with forward visibility being restricted from a greater distance by the horizontal and vertical alignment of the carriageway. Pausing there. So what they are saying, if we're to make sense of it, and it's not to be self-contradictory, is they're saying, notwithstanding that you can achieve manual for streets required visibility, forward visibility is still restricted, albeit up to standard. Yeah?
Yes, from a greater distance is what they refer to.
And it's within an area of national speed limit, and what those things collectively mean is that there is a risk that has an effect on driver expectation, which is they're not expecting, because they can't see that far ahead and they know it's a national speed limit road, or at least some drivers might not be expecting cars to be pulling out of this junction. And that's how we can have an accident risk.
Yeah.
Okay, good. And we may as well know, while we're in here, what their recommendations are. Their recommendations are, firstly, that the start of the 30 mile per hour speed limit zone should be relocated further south, should be brought south of the junction in order to incorporate it. The junction should be brought within the 30 mile an hour speed limit.
It does say that, yes.
Yeah. So drivers, and the purpose of that is so that drivers know they're entering a predominantly residential area, and therefore their expectation will be actually there might be a vehicle coming out of here.
Yeah.
In addition to that, it's further recommended within the detailed design a warning sign or signs are provided on the northbound approach to junction, warning drivers of the junction to the left. So first of all, we know this is in addition to, not alternative. They're saying bring forward or bring further south the 30 mile an hour zone and erect warning signs on the northbound approach to the junction to warn of either the junction or the 30 mile an hour. So, okay, thank you. So two things in their recommendation.
Two separate things under a theme I would consider as signage and awareness.
Okay. Now let's go to the Amy RSA in Mr. Carey's appendices. And when you have that, could we go to problem 3, page 9, which is the problem being restricted visibility on the right. And then this, if you look into the section detail and go to the 4th line, about 2/3 of the way along a sentence starting, even if the visibility standard is achieved as per the Manual for Streets requirements, which is stated in the transport assessment, when the junction will first become visible for motorists approaching from the south, this will be created somewhat to the left of the direct line of vision for the driver. So they are not contesting that the visibility of the standard, that the transport, they're obviously aware, first of all, that the transport assessment says we can achieve manual for streets requirements, yeah? And they're not saying you can't. They're saying even if you can, there is a problem here.
They've identified a problem with the summation, as you said, even if the visibility standard is achieved, then it talks about the junction being located on the left.
So there isn't any, the difference that you've highlighted between Amy and Midland Road Safety is not actually correct. They both operate on the assumption that you could achieve it, but there's still a problem.
That's not necessarily a point, I would agree, in the entirety of the document. Taking that one line into account, it suggests that Amy accepts visibility can be achieved, and with the achievement of that visibility, there is still potentially a problem for consideration. However, there are other references and problems highlighted in the Amy report which do make references to critical visibility being obstructed by the cresting.
But if we look at this, so this is the problem where they say, first of all, so there's same in problem 2 as well. So there's restricted visibility to right in problem 2, restricted visibility to right in problem 3. And problem 4 is where, well, in fact, let's go to problem 4. Problem 2 is where they look at the 60 mile an hour speed limit and the effect of that. And they say there, under the detail, as per the previous problem, the visibility is somewhat restricted to the right. So they're saying, in the same way that we said visibility was restricted to the right in the previous problem, we're saying that again here. They're not making any additional point. They're not saying it's more restricted, actually, than we accepted in problem 3. They're saying, look at what we said earlier about restricted visibility, and now we're identifying something else that's problematic.
Yeah, so in response to that, I would suggest they keep referring to restricted visibility, and we've demonstrated visibility is not restricted.
But so did MRS, and we agreed that what they meant by that was visibility, forward visibility is restricted, notwithstanding that the required visibility displays under manual for streets can be achieved. They were talking about it being, you're not having a greater visibility at a greater distance because of the horizontal and vertical alignment.
Apologies. So I understood that the line of question and discussion was around the additional visibility references within the Midlands Road Safety Audit. Yeah. So to paraphrase what I took away from their assessment is that visibility is achievable based on the drawings provided. However, given the character and the context of the road, if you wanted greater levels of visibility, then drivers may be unaware of the changing character.
And you've said we've gone out and measured and we can achieve visibility at 42.7 metres, I think it was. Yeah. And we think, although we haven't got the evidence in front of us, that you can see a little bit further back, yes, another 10 metres.
Give or take, yeah.
Okay, but it's accepted that you can't see realistically beyond that?
Oh, yeah.
Okay. And what I'm putting to you is it's clear what both of them are saying is, even if it's the required visibility is 42.7, the fact that you have a relatively short distance between that and what the boundary of what you can see means that it is restricted.
In that context, yes.
Okay. Well, I'm saying they mean the same thing by restricted. They don't say anywhere, do they? We don't accept that you can achieve the required visibility under manual for streets.
Perhaps not. I don't recall reading that explicit phrase.
Okay. Okay then. If I go back then though to what you say in your proof of evidence at identified the conclusion, I think it was at page 20, paragraph 516, where you said there is no material consideration to suggest the proposals can be considered as unsafe. We've agreed that the RSA by MSR is a relevant consideration to be taken into account by the inspector. material in that sense?
Sorry, I'm just moving back to the page. Page 20, paragraph, which one are we looking at, sorry?
Paragraph 516 in the last line.
516. Thank you. Okay, yes.
Yeah. I mean, I'm just putting it's clearly wrong what you say there. There clearly are material considerations to suggest the proposal could be or would be considered as unsafe. You may not agree with them, but there are two reports which identify a safety problem with this junction arrangement. Both RSAs identify a safety problem.
Both RSAs highlight problems and potential solutions, yes. Or
Okay.
recommendations, I should
So
say.
there are material considerations to suggest the proposals would be considered as unsafe. That doesn't necessarily mean that you have to conclude they are, but there are material considerations to suggest they could be unsafe.
I understand I believe I understand the point you're leading to, but it's not one that I would agree with, unfortunately, and perhaps others will have a different interpretation.
Do we agree that both road safety audits suggest that this junction could be unsafe?
They do.
Okay. We accept
However-
that they're both material considerations.
No. So what I would focus on, or my perspective, I should say, is that whilst the RSAs highlight problems, I don't personally consider them to be material because the majority of the problems are either not qualified because through proof of calculating visibility displays, they are not necessarily as valid, or the problems that talk about character or awareness or some of the themes that come from the Midlands Road Safety Audit can be rectified through the introduction of additional features such as gated features or arrivals.
Okay. I wonder if this is a matter of semantics here and what you understand by material
Perhaps, yes.
consideration being
Yeah,
different from me.
I'm
Can I
sorry.
use a different term? There is relevant evidence to suggest that the access arrangements may be unsafe.
Yes.
So you agree with that proposition? I'm not sure exactly what you mean by that. Okay, but that's not what you were trying to say then in that final sentence. Is what you mean by material, there isn't evidence in your view to demonstrate that they are unsafe?
That's a part of it. So, like I say, going back to what I was reviewing when I was drafting this, not that I would suggest the AMI road safety audit introduced anything new or features which we would take into account and say, oh, hold on a sec, we didn't actually think about that. However, when drafting my evidence, I had not seen the AMI road safety audit. Notwithstanding that, though, the position I don't feel has changed in respect of whilst both road safety audits, the one undertaken by Midlands Road Safety identified one problem, the subsequent AMI RSA, in terms of the chronological order in which I saw them, identified more than one problem. The problems, to give them that terminology, that we accept could be rectified are rectifiable. So taking that through, there are no further material highway safety problems from our perspective.
So again, I'm trying to be fair to you by putting this, because I think...
No, I appreciate that. Thank you.
I think we've agreed there's relevant evidence to suggest in the RSAs that the junction may be unsafe. Your answer to that is, though, in your view, the issues that are flagged up there are rectifiable, the word you've just used.
Yes, yeah. Either not applicable or rectifiable.
Either not applicable, some of the problems you don't agree with. Mm-hmm. You don't disagree with all of the problems.
No. I think, to be honest, some of those recommendations on reflection are sensible.
Okay, thank you. And so, in particular, you haven't said, and I just want to check this is right, you are not saying that MRS got it totally wrong, and the problem that they've identified, the risk of collision they've identified, because of the factors they've identified, the national speed limit and what they refer to as restricted visibility. You're not saying that isn't a real issue. You're saying, I think it can be rectified.
Agreed.
Good. So the question is then, that's not a reject the problem response. It's I think your answer to that is twofold. Mm-hmm. It's right. You say, first of all, it's a stage 2 issue.
Yes, so specifically I would say items around signage and awareness typically come through a stage 2 audit.
Okay. So what about the 30-mile-an-hour relocation? Are you saying that's a stage 1 or a stage 2 issue? Or both?
It could be picked up at either,
Okay.
to be honest.
So it depends. It might be a stage 1 or a stage 2, but it's not inappropriate to look at it at either necessarily.
No.
Okay. And you're not suggesting, because you didn't in your evidence in chief suggest, as I understand it, you're not saying the inspector's in a position to conclude there is no need for the 30 mile an hour speed limit zone to be extended southwards to incorporate the junction. You're not saying the inspector can conclude that's not necessary or appropriate. You're saying it's a matter to be decided later on.
What we developed and the point we arrived at with Derbyshire County Council did not include an extension or relocation of the 30 mile an hour speed limit. So at the point of submission, negotiation, and then ultimately when it reached the planning committee stages, amendments to the 30 mile an hour speed limit were not part of the proposals. It was not deemed necessary by Derbyshire County Council Highways officers when following their review of all the submission and the documents that we put together. So the emergence of the 30 mile an hour was first presented through the Midlands Road Safety RSA, which was undertaken in response to the appeal in which we are now in. So there was never really the opportunity to retrospectively look at any recommendations that we might want to accept as a result of the RSA stages and then fit them back into the scheme for which we're discussing today. But notwithstanding that, I think if there are conditions around extensions to speed limits or gateway treatments, for example, I don't consider that would be particularly challenging.
Okay, and sorry, so I don't know what the answer to my question is, sorry again. Are you saying you agree that whether or not there needs to be a relocation of the 30 mile an hour speed limit is an issue that has to be determined now, as before planning permission is granted?
No.
No, you're saying it can be determined later?
No, what I'm saying is the proposals without the relocation of the 30 mile an hour limit are still acceptable in our opinion and of that of Derbyshire County Council. However, if people involved in the decision-making process are minded to accept some of the recommendations from the resultant RSAs following the inquiry process, that would not necessarily be a disagreeable process.
I'm sorry to be pedantic about this, but in the end, I think the inspector may need to know about it in terms of what she has to decide. Okay. So you're not saying to the inspector, I accept the 30 mile an hour. Well, I'll put it like, do you accept that it is necessary, or do you think this is something to be determined at a later point? The RSA teams say it is, but yeah, go on.
The RSA teams say it's a recommendation.
Yeah.
Okay. However, it's not the view of Derbyshire County Council as the Highway Authority. And through our assessment and through reviewing traffic trends and how drivers behave in environments around manual for streets, for example, we've evidenced that the more engineering features you introduce into a highway, the greater confidence and therefore speed that drivers begin to exhibit. So if the question, and I apologise, sorry if I'm going off on one, but is the question, is a 30 mile an hour speed limit relocation necessary to approve the scheme? No, I don't believe it is. Would it have a beneficial impact if some people held the view that those kind of features need to be produced? Yeah. Can it be conditioned? Yeah.
But what your position on that then isn't consistent with the recommendations of the RSA teams, is it? Because they do recommend the 30 mile an hour.
They do recommend, yeah.
Okay. But you're not saying you necessarily accept that recommendation?
I'm not saying that we necessarily agree with the recommendation, but if it's generally thought as a sensible approach to progress, okay, it's something we could accept.
Okay. You talked about what the Highway Authority's position is. You said it wasn't a requirement of the Highway Authority. The Highway Authority, of course, didn't have either of the benefit of either of the RSAs when it was being consulted, did it?
They did not.
No. And you referred in your evidence in chief, you said, I think, that you have, although, I think we can also agree, as a matter of fact, there was no response. There was no designer's response from you other than the one that you gave in this morning in evidence in chief. There was no written response to either of the RS. I can understand why the Amy one there wouldn't have been, but you didn't provide a response to the MLRS
We didn't include a completed designer's response within our appeal submission because we didn't actually get a response from Derbyshire County Council. So following receipt of our Midlands Road Safety audit, we did actually complete a designer's response form, which was consistent with how Derbyshire County Council like designer's response forms to be undertaken. We approached Derbyshire County Council, we shared the road safety audit with them, and we gave them our response form as well, our designer's response form, but we did not get them to engage or respond. I suspect strongly it's because of the appeal nature of the site in question.
They think it's out of their hands now.
Perhaps.
Okay. Yeah, so the answer is then, we also don't know how Derbyshire County Council will ultimately respond to this.
We don't.
And there's two possibilities. They may say, we're inclined to agree with you that there isn't a need for the relocation of the 30-mile allowed speed limit, or we're minded to agree with the two road safety audit teams that there is. Mm-hmm. And what that will require is also yet undetermined, isn't it? What exactly would be required for that relocation, how far it would have to go, mm-hmm. Whether it would involve widening, extension of the footway, so that it appears properly as part of the built-up, the residential area. Yeah. Those things are not things we have any view from Derbyshire County Council on yet either.
We have not discussed the relocation of speed limit signage with Derbyshire County Council.
Okay. But we know the speed limit was all previously with the development to the north, further up Wyston Road, the neighbouring development. Mm-hmm. There was a requirement of that development to bring forward the 30-mile-an-hour speed limit and the physical infrastructure associated with it.
It would be a sensible assumption, but unfortunately I wasn't involved in that design, so can't say.
Okay. If it is judged by whoever it may be appropriate to judge it, necessary or appropriate to do that, what we also haven't had any evidence of from yourself or anyone else for the appellant is whether that could be done compatibly with the scheme that is before the inspector. And I note when I say that as well that you didn't say in chief, I am satisfied even if we have to bring forward the 30-mile-an-hour speed limit zone, that wouldn't involve any material alterations to the scheme. Is it fair to say, therefore, that you are not in a position to say one way or another whether it would?
Apologies, can you elaborate on the question?
Yes, so you haven't said yet. I'm just noting that you haven't said yet, mm-hmm. but I'm giving you the chance to say it now, so we can examine it if you are going to say this. That even if it is necessary or appropriate to extend the 30-mile-an-hour zone further south to incorporate the junction, that can be done in practice without making any material alteration to the appeal proposals.
Through past experience of similar circumstances in other locations, yes, it can.
You think it can? Okay. Where do we see that demonstrated? Is there any demonstration of this on a plan? For example, something to show illustratively at least, this is how you would bring the 30-mile-an-hour zone, and this is how you would do it without, for example, having to take away any of the Category A trees on the eastern side of Wyston Road?
That's not a design we've prepared to date.
Okay. But how can the inspector conclude that that is possible without even having any illustrative material to form a check against?
In this particular scenario, from a personal perspective, I would, recall my professional experience of having been in similar situations in the past, and not once ever experiencing a scenario whereby a speed limit couldn't be extended or altered because of the presence of trees or foliage.
Okay, so we have just to look at the plans then. If we could go to the agricultural report, I think the inspector helpfully gave me the date earlier on, sometime in 2023, September 2023 or June 2023, CD 2.13.
So yes, I'm looking at the report. Which references?
Yes, apologies. I'm just bear with me and I get that open. I need a bigger laptop. Yes, CD 2.13 useful plan. If you go to the plans at the back, the survey plans at the back, and it is number 4, I think. It's about the 28th page or 29th page. 11008T04B.
I see it, yep.
Okay. And we have the hedgerow marked as H8B in blue in a blue rectangle or strip.
I see that.
And then we have beneath that G2A, which is a group of category A trees we see from the key. Unfortunately, we don't have the junction, but we can see that the category A trees extend quite close to the carriageway of the road, don't they?
The plan doesn't include a great deal of topographical or OS data, so I'm not sure how close to the extent of the highway boundary or the edge of the carriageway they do extend.
Is the red line is the carriageway, isn't it? It appears to be. Yeah, I think actually it's been pointed out there's a more helpful plan further on, which there would be, at about 3 or 4 pages onwards, 11008T08C.
Okay, yeah.
So what we see there is the red strip is the hedgerow being removed for the access. The green, the retained. And just on that point, could you just clarify that? Because I think you said your understanding was that some of that hedgerow was being removed to preserve the visibility splay.
Removed or cut back.
Oh, cut back.
We would have to overlay the visibility display drawings that we've provided.
Okay, there may be some inconsistency then there, but in any event, that's not I suppose my focus here. My point is that beyond that, there is the category A trees, and they are pretty close to the boundary of the carriageway.
Upon review of the drawing, I still don't determine the relationship of the edge of the carriageway to the areas marked GT2A. I presume that's the green hatched area you're talking about, with the blue edging.
It's not the line to it's not the solid black line to the east of the green hatched area. Is that not the edge of the carriageway?
Potentially. I've not produced this plan, so it's hard to say for sure.
If it is, and if the carriageway needs to be widened and potentially a footway added, then isn't there a clear risk that some of the category A trees will have to be cut back or felled?
Well, there's a couple of items you mentioned there, and apologies if there is no proposal to widen the footway, to widen the carriageway, or extend the footway to the south of the site. Forgive me, I was looking at the concept of placing a speed limit sign somewhere to the south.
Yeah, but the highway authority has required has already required widening of the road. You're proposing that further up in the vicinity of the junction.
That's right. Yes, opposite the junction and to the north.
And that's to tie in with the road further north into the residential area.
Correct.
Yeah. And so if the residential speed limit is being brought down further south and the junction is becoming part of the residential area, and the whole point of this is to show, according to MRS, that this is part of the residential area, it's at least possible, if not likely, or that the highway authority would say, no, you can't just stick a speed limit sign, you're going to have to widen the carriageway and or potentially add a footway.
Not necessarily.
I didn't say necessarily. I agree, because we can't say, because we haven't got the highway authority's view. It is a possibility. A possibility.
There are many possibilities.
Well, it's the view, I think, of Amy, but as well. So it's not. It's something which a highway professional might deem to be appropriate and necessary.
Well, they may, but the point that I would rely on is that so far they haven't. So I'm
But
not
they haven't
sure.
given us any response. They haven't said we won't require this, we will require this, or anything. We just don't know what will be required by the Highway Authority.
Well, to date, no changes to the south of our access in respect of carriageway widening, footway or speed limit changes.
It might have been different if you'd sent that to them and they'd said, look, we disagree with that. We're happy with what we agreed with you before, but we haven't got a response of that nature.
We don't, no.
No. So can I just go back to it then? If it is required, can we agree this? It cannot be said, if the highway, if the road has to be widened to, is it 5 metres?
5.5.
5.5 metres. Do you say that wouldn't, that you can be certain that wouldn't involve any loss of the Category A trees? It doesn't appear to be something you could be confident about based on that plan.
With respect, it's a hypothetical design situation that I don't feel entirely comfortable about.
So the answer is you
responding to.
can't say that?
There are many hypothetical scenarios that we could discuss from a highways perspective. I would suggest they're all very unlikely. You mentioned widening the carriageway to the south to 5.5 metres. That would be an incongruous design change from my perspective, given that the highway to the north measures only 5 metres wide.
Well,
So it would go wider, tapering into narrower. Equally, the concept of increasing the carriageway geometry in relation to speed limit reduction would probably be an incongruous design.
that isn't my
alteration as
question
well.
again. I mean, you said that we can hypothesise about what the Highway Authority may say, and you have a different view from Mr. Carey on this. But given that we don't know, what I'm saying to you is, if the road had to be widened to 5 metres or 5.5 metres or even 4.5 metres, it is not clear at all on that plan that that could be done without removing the trees, or do you say differently, and if so, why?
No, it's not clear because it's not
Okay.
been designed.
Okay, thank you.
It's not been explored.
Okay, can I take you next to the checklist in GG 119 briefly, and then we'll look at the few issues about the Amy RSA. The relevant bit begins on page 31.
Yep.
And you were taken to the second row, near existing road interface in your evidence in chief, and you said this is about changes in character. And I think the point of the questioning and your answers was that this is something that is looked at stage 2.
Yes.
But it's also, if we look at stage 1 column, it's also looked at stage 1, isn't it? Will the proposed scheme be consistent with the standard of provision on adjacent lengths of road? And if not, is this made obvious to the road user? Does the interface occur near any potential hazard, i.e. a crest, bend after steep gradient? That could have been written for this junction, couldn't it? There is an issue about whether the road, what the difference is between adjacent lengths of road and how they will appear and the effect that will have on the road user. And then there are potential hazards arising from crests, bends and gradients.
It does say that, yes.
And that's an issue then, isn't it, that is properly for consideration at stage 1. Good, thank you. Similarly, if we could go to page 37. Under layout, the last two questions at the end of the first row: are any junction sited on a crest? Is the junction type appropriate for traffic roads and likely vehicle speeds? So again, it's appropriate to consider the impact of the crest and of likely vehicles and vehicle speeds at stage 1.
The crest is in the vicinity. However, the junction is not sited on a crest.
Correct, okay. But what
The junction type appropriate for the traffic flows and likely vehicle speeds, yeah, it's there. It's part of the stage 1.
Yeah, good. I was going to say, the other thing is, we're not tied to these questions. These are example questions,
Sure,
aren't they?
yeah.
It's a prompt to thinking. What sort of thought should you be having
Yes,
when
yeah.
you're assessing it? Thank you. So, okay. And similarly, obstructions from street furniture, we see, are a stage 1 issue for visibility. Obstructions in visibility displays. So I know what you're saying. I don't want to spend long on it because I don't think the main point in this case is the warning sign on the site, on the position of the site access. You say, well, that's kind of immaterial because it's just a pole and I wouldn't really regard it as obstruction. But that's something that the checklist says that you ought to be thinking about at stage 1.
Yes, I think it's probably also worth pointing out that this document, whilst does provide an overarching guidance for undertaking road safety audits, specifically has been prepared for audits on the trunk road network.
Yeah.
The signage characteristics of the trunk road network are different to what we look at here.
Fair enough. But it's used for non-trunk road purposes. I mean, and you've
In the absence of anything else, yes.
Your road safety consultants have done the same, referred to it. It's how road safety professionals operate.
They always have, yes. Yeah.
Okay, thank you. And then if we go then finally to page 42, we see stage 1 issues. Is there likely to be sufficient highway land to provide the traffic signs required? So again, it's maybe not exactly on point, but it's a prompt to thinking. Considerations of what land is necessary to provide improvements to secure road safety is an appropriate thought process to go through at stage 1.
Adoptable land is referenced there, yes. Yeah.
Okay. So the issue about, well, it is right to think at stage 1 about, do we have sufficient land in order to bring forward the 30-mile-an-hour speed limit? That's a proper consideration at stage 1. Yeah. Okay. Thank you. Do you accept the fact that 2 road safety teams have reached the conclusion that the 30-mile-an-hour speed limit should be brought forward, gives it greater weight?
They have both included it as a recommendation.
But the fact that you've got 2 teams instructed by opposing parties to an inquiry, independent, they're independent, and we're not suggesting otherwise about MRS. The fact that they've both come to the same conclusion on what I would submit as a key issue like this, but the fact they've come to the same conclusion about the speed limit gives their advice and recommendations greater weight, doesn't it? You've got a body, you've got a body of professional opinion. In fact, it's unanimous from the road safety teams.
So there are 2 independent organisations arriving at the same recommendation that the 30-mile speed limit needs to be changed. The amount of weight to be applied to that is not necessarily a decision I would make, other than referring back to the point that prior to the refusal, it was not considered necessary by the Highway Authority to introduce that change.
But as we've said a few times now, we don't know what the Highway Authority's take is on it now that they're aware of it, because they're not talking.
To suggest they were unaware of it before, they have considered, well, I tell you what, I suppose that's speculation. I would like to think, in the role of the local highway authority, they would have considered all the highway safety impacts, and that
I'm
they
sure
should have
everyone
done.
would like to think that, but whether it always happens may be another matter.
So yeah, I won't speculate on what they thought.
There isn't any contrary evidence from any other road safety qualified professional to gainsay what they recommend, is there?
No.
And this is no criticism of you personally, but it's the limitation of your position. In certainly at least one respect, it is, you are defending your scheme, and I know that you're trying to do it as objectively as you can, but that itself means that one has to treat your evidence on that with greater caution because you're defending your design. Mm-hmm. Do you accept that?
No, I don't. The amount of caution one would apply to my evidence is for their choosing given the circumstances. As I mentioned earlier, we are delivering a service to the appellant, and I would not feel comfortable personally, and I would probably be negligent of my duties to the profession rather than the appeal inquiry process, if I ultimately ended up trying to drive through changes or schemes which I felt uncomfortable or contrary to, the broad aims of the policies and the objectives of the transport planning industry, the IHT and the ILT.
Yes, but and as I said, I'm going to be perfectly. I'm not suggesting that you're doing anything other than that, but I'm saying that it's a matter of unconscious bias when one's defending one's own work. It might be that one's trying to be as objective as we can, but it's not always possible.
Well, the nature of unconscious, I guess.
Yeah. Okay, thank you. So the net result is, isn't it, that the inspector can only conclude on the evidence that there is a significant unresolved road safety problem here at the access, which may or may not be capable of being dealt with later.
Could you repeat the summation, please?
The inspector can only conclude on the evidence that there is an unresolved safety problem, which may or may not be capable of appropriate resolution later. But you can't say it will be.
I feel that's a tricky one for me to answer, not least because the inspector, as everyone else in this room, will interpret and understand slightly different things from the evidence that's presented. Okay. So it's difficult for me to answer that one in a succinct manner, I'm afraid.
Okay. She can't say whether or not the highway authority will agree with you or agreed with the road safety audit teams that the 30-mile-an-hour speed limit should be extended, because we don't know what their position is. I think we'd agreed that we can't. There isn't any information on which to come to a conclusion as to what they will decide.
Okay. So again, apologies, Mr. Hunter. Whilst Derbyshire County Council have not seen the road safety audit, so there is an element of what you're saying I can agree with. The overall thrust and the conclusions we're moving towards is not something I would necessarily agree with, ultimately coming back to the fact that Derbyshire County Council have already approved the scheme as been presented. Okay,
right, so probably we'll run through the possibilities. The inspector might conclude, using her own judgment, I am satisfied either way. She could reach a decision herself and say, I'm satisfied with the evidence that there is a real road safety problem here, and I think it is likely to require the extension of the 30-mile-an-hour limit. That's a possible option, isn't it?
She may.
She could conclude conversely, notwithstanding what the road safety teams, I don't think it is. I don't think it will be required, yeah?
She may.
Okay. But the other one is that she might say, I don't know whether it's going to be required or not. It could be, it couldn't be, and I can't say one way or the other. So there's three possibilities there.
She may.
Yeah. If she concludes, if in a scenario where, if she concludes that it is necessary, you have accepted that it's not clear. I'm sorry, but I should have made clear when I put that question is, and it may require some additional land take or operational construction area or some use of the land at the margins of the highway. You've accepted that it's not clear from the plans whether or not that would interfere with the trees.
Okay. So in the hypothetical scenario we're discussing now, which is a tricky one to go through, if there's a scenario whereby the appeal is upheld subject to a series of conditions, and one of those conditions may be gateway treatment or relocation of the 30-mile-an-hour speed limit, whilst we don't have a drawing to show how that would look, I would have a high degree of confidence that it is achievable within the confines of what is available. And I can expand on that, if you like, slightly, because based on our interactions with Derbyshire Highway so far, there has been no requirement to widen the carriageway, request to widen the carriageway. So I would suggest, in the event that there is a condition attached to the scheme relating to introduction of gateway features and 30-mile-an-hour extensions, that could be addressed without physical alterations to the geometry of the highway, but with introduction of a speed limit signage further south and Dragon's Teeth. And my strong belief, and it's hypothetical, is that given Derbyshire County Council were prepared to accept the proposals without any of those interventions, then if it was deemed necessary as a part of the appeals process, then they would probably accept it in that scenario as well.
Why do you say that when they didn't accept similar measures for the development to the north?
Pardon?
Why do you say that when they required the road to be widened to the north and the footway to be extended? Why do we assume that they wouldn't require something similar for an extension of the road?
Well, unfortunately, notwithstanding the fact I wasn't involved in the discussions around the Red Road development to the north and what was required and what the highway alterations were, it's not a question I can answer.
Okay, well, I'll leave that then.
Okay.
Can we move on to traffic impact then, please? The difference between us is whether or not, I think in light of your examination, Chief, the difference is it's accepted, you said, there is an impact on the 5-arm junction. You say it is not adverse, however, whereas Mr. Carey says it's moderate adverse on your figures. Yeah, that's the essential difference.
Okay.
Okay. First of all, I understand what you mean by impact then. How can there be an impact on the junction which is neither adverse nor beneficial?
When I refer to impacts on the junction, and forgive the presumption, I assume you're talking about the 5-arm junction?
Yes.
The Lindsay modelling work. Okay. So let me just jump into my rebuttal, which provides the clearest summary of that. So, table 2.6 in the rebuttal comes back to the Lindsay modelling work. Impact, yes. Well, we can see small increases in degrees of saturation and mean max Qs on some of the arms during peak periods. So that is what I refer to as impact.
So there's a difference. I think, again, it's a terminological difference. An impact is an effect on something, isn't it? So there is an effect on the junction. Now, if the effect is trivial, negligible, you would say there's no material impact, would you not?
Yes.
Okay, which is the same as no impact.
Okay, there's terminology, forgive me.
Okay, so it's a terminology. So you say there's a difference, but the difference is immaterial on the operation of the junction, and therefore, in the way I would put it, there's no impact. So you're saying there's no, it's any change is immaterial or negligible.
Yeah, I think we've described this as imperceptible, negligible, certainly not severe, detrimental.
Okay. The question raised by this part of the refusal is whether there is a cumulatively, or was raised, whether there was a cumulative severe impact. Yeah. So it wasn't ever the council's case that this development on its own was going to have a severe impact on the highway network. The question was whether it, in combination with other developments, would have a severe impact. Yeah.
Correct.
Okay, and that's the same terminology as used in the NPPF. You look, it's the residual cumulative impacts. Are they severe or not? Okay, so if we look at your table 2.6, we can see that there is the difference between the 2024 baseline and the 2032 future plus other committed development and this development is, in terms of saturation, it goes up 9% on the Sturston Road arm.
From the current baseline to...
from the baseline to the first and third columns.
Yeah, today as in future, and then versus future with developments,
And whereas the difference between the 2032 future committed, so the second and third columns, which shows what it will be like in 2032 without the development and what it will be like with the development,
That's correct, yeah.
So that tells, the difference between that tells us I was going to use a Latin word, I don't know why it occurs to me, but solus impact, like the individual impact of the development, not the cumulative impact of the development.
That's right.
We get by comparing those two columns, and we get 3.5% increase in saturation, degree of saturation.
Yeah, that's the difference between those two columns.
And we get an increase in queuing of just over 2 vehicle lengths in the main max queue.
On this table, yes. Yeah.
Okay. That, I think, is, in Mr. Carey's view, still a material adverse impact. You obviously see it differently. But isn't the appropriate comparison, if we're looking at cumulative impact, is a bit broader, isn't it? Because what we've got to consider is, does this development in accumulation with other developments have a material adverse impact, or does it extend to the level of severity? And in doing that, we're looking at the effect of this development together with other committed developments and growth.
So the refusal does refer to cumulative development, and I think I understand the commentary in the question. So I'll try and answer, but forgive me if I go off beat. The way we go about junction capacity modelling work across the industry in all scenarios is to look at the baseline, future without development, and future with development.
Yep.
The way we interpreted cumulative impact would be to consider the development impacts in the future with the committed background growth.
Yep.
The alternative strategy, or something that we could have presented but hadn't, would be to look at a 2024 baseline, i.e. what happens now, and then put our development trips onto that. That, I would suggest, is not a cumulative assessment.
Yep.
A cumulative assessment is to look at the baseline, to growth it, and then add to our development trips on top.
Yeah.
Yes.
And so we can say, yeah, okay. But what I'm saying there is that the impact on the cumulative impact on the junction that is demonstrated by that is an increase in 9% on the baseline.
I would, to an extent, I see the figures you're talking at, and I can understand the perception that you're taking. However, when we discuss highway and junction capacity modelling works with highway authorities, the future committed development, so basically at the same measuring point, if you like, on which we're saying what's the impact of these proposed development trips on the junction.
Yep.
If you look at that with and without development, so the cumulative element takes you from 79% to 85%, if you like. So that's the biggest jump. Without the development proposals occurring, that junction, in theory, without any intervention, will see that level of change. So the additional impact of our development on top of cumulative is the difference then between 2022.
A little bit, yeah. Okay. Right. You say that this isn't a material impact or an adverse impact, but the effect of it is we see there either an increase in, depending on how you measure it, then between 5.3 vehicles in the mean max queue to 2.1 vehicles compared, depending on which columns you compare. Okay. And that is going to extend traffic back to the Park Road junction, was the evidence of Mr. Carey.
Was the statement of Mr. Carey. I've not seen any evidence.
Yeah. It was his statement in evidence. I mean, could we take up? I don't know whether you can do it at the same time if you've got a laptop, but have you got paper copy? You can look, so we can look at both. If you can look at Mr. Carey's, or at least easily flip between them, Mr. Carey's main proof, and within that, the figure 4.3 on page 10 showing the junction.
Yes, this is page 10, did you say?
Yes.
Yeah.
So the issue is traffic backing up, queuing at the junction, back up to Sturton Road to the east. Is it not? Traffic entering the junction from Sturton Road.
So the junction traffic approaching the junction from the east.
Yeah. Yes.
Yes.
Yeah. So the queue extends back towards Park Road junction.
The queue would be in the easterly direction.
In the easterly direction.
Yes.
And the queue, according to your figures, is between 27, it's 27 in the 2032 year with committed and this development. Thanks. I should do full thing. And a car for these purposes is taken to be a PCU 6 metres. So 27 times 6 if they're bumper to bumper. Yeah, I'm told it's over 160 metres.
Okay.
Okay, and that on Mr. Carey's evidence would take you back beyond the Park Road junction.
Okay. Following that same train of thought, I mean, this is not calculations that we've done yet, but if we're doing the calculations on the hoof, what would 6 times 24.9 equate to, which would be the future year scenario without the development?
It would be, well, I think even with my terrible maths, I think I can work that out. That's about another 12 or 13 metres, or less. 12 or 13 metres less.
Yes.
And the difference between the 2024 baseline is just over 5, so it would be 5 times 6, between something over that, so about 30 metres, just over 30 metres. So the difference between 2024 and 2032 with this development is just over 30 metres, and that between 2032 future and with or without the development is 12 or 13 metres. So can we agree those figures as approximate?
Yeah, I mean, I'm happy to accept that a PCU is measured at 6 metres, and if you measure mean max queue length, those are the approximations that you would employ, yes.
So the question was, I was putting it to Mr. Carey's evidence, because he said it in evidence, his belief, having looked at matters, was that the queue would extend in 2032 with this development, would extend back beyond Park Road. Do we agree that is the case?
I can't necessarily agree to it until I've actually done.
Okay.
I mean,
Well,
this is your
evidence,
assertion, and
It all feels a bit ethereal to me.
Right.
yeah,
It's not a different. Okay, well, but perhaps we can.
no, I
Take
suppose
the maths
We
outside
need
the
to know how long the
inquiry.
road is,
Sorry?
don't we?
Sorry.
We need to know how long the road is.
Yes, but I presume it's
it
not
could be
beyond the
1,000
wit of
metres.
Two bright highway witnesses to do. So, okay, well, I put my point to it. That was his evidence. You're saying I can't do that without measuring the road, and I haven't done that yet.
yes.
No. Okay. Let me put it like this then. If the extension of traffic queuing backwards beyond to the next junction, that is an impact on the highway network of materiality, isn't it?
Not necessarily. Again, perhaps we're using different understandings of materiality, and apologies, I'm coming at this as a transport planning perspective. But what I see when I look at these figures here is that the development proposals before us now have the opportunity in a robust modelling scenario to increase the queue by 2 vehicles. Okay, that's the difference between the do nothing scenario or the do development scenario. So I wouldn't necessarily rely too heavily on the 2024 versus 2032, because 2032 will happen irrespective of the outcome of this development, unless there are other highway interventions there. So that's typically why, from a transport planning perspective, highways authorities will focus on the difference between the future without and the future with scenario. So in those scenarios, we're potentially adding 2 cars as a bit of a robust worst case scenario to the back of the queue. Now, what I've not done is calculate where the back of the queue would be without the development, and then where it would be with
I know
the
you haven't, and that's but I asked. But if you've got traffic, but my question was a sort of theoretical one, because you said you haven't done the calculations, so we don't know. Again, but if you have traffic that is backing up from one junction into another one over that junction, isn't that almost certainly likely to be an adverse effect of, I don't know what words to use apart from materiality, one that you need to take into account, because it's bound to affect the operation of that junction if you've got cars overhanging it.
It depends on the level of impact. It is a very hypothetical question. It's not a junction that we were asked to model by Derbyshire County Council as part of our pre-application or post-submission works. The statement of common ground in the initial reasons for refusal did not specify that particular junction as a reason for concern. The only element that jumped out of the Derbyshire Dales District Council that provided additional light on reasons for refusals were questions about the validity of the survey data being undertaken in July 2022. So that's what we sought to address when we updated our modelling work. We recaptured a baseline for 2024 and redid those figures. It was only later then did we realise for the first time that the authority, as part of the appeals process, would like us now to examine the impact of on the five-arm junction. So it does feel unnecessary, given the evidence I've given previously about the level of impact, what would be considered material, and what is discernible. And therefore, to continue spilling onto the next junction and then to the next junction, it's a difficult one to answer because we've not really looked at that.
So can I ask you this? If you said it wasn't required, you made the point, it wasn't required by the Highway Authority, okay? Mm-hmm. You said in evidence in chief this morning that you had given, I think you provided the Highway Authority with information on the number of vehicles you thought the development would put onto this junction. Okay. Is that in the, first of all, is that in the evidence anywhere? The information you provided to the Highway Authority?
It's in our transport assessment.
Oh, it was in the transport assessment?
Yes.
Okay, well, I'll be able to check that, thank you. What I want to say is this: if the Highway Authority had said to you, look, this is, like Mr. Carey had said, look, this is no pinch point of concern, it may be that you're under the 30, but because of the sensitivity of this junction, we'd like you to assess it, would you have refused to do so?
No, probably not.
Would you have considered it an unreasonable request?
I think it would have been considered a reasonable request, I should say, apologies, in the context, had the council highlighted existing concerns with regards to capacity or air quality. The guidance on transport assessments documentation that we referred to previously does set this threshold of, broadly speaking, any impact of less than 30 two-way movements on a junction during a peak period does not necessarily qualify for junction modelling work. However, there is a caveat as well, and that doesn't preclude the need to consider additional junctions if there are disclosed concerns or pre-existing concerns about junction capacity or air quality.
Okay, so the kind of things that Mr. Carey raised in his group.
Yeah, precisely. I mean, the council didn't, so neither did we.
Yeah. So the answer to my question is, if someone at the council, someone at the Highway Authority or the council had come to you and said, we'd like this junction modelled for the reasons given by Mr. Carey, you would have considered that a reasonable request? I
would. However, I suppose that the caveat there is, and again, correct me if I'm wrong, that the rationale for our undertaking that additional modelling work presented by Mr. Carey was derived from the 2018 ACOM Ashbourne Town Centre study. The modelling that underpinned that particular study looked at the operation of the junction in 2018 and found it to be operating over capacity. As we've heard, and to what degrees perhaps is still to be answered, but there has since been changes to the nature and character of that junction, which Derbyshire County Council have been aware of. Yeah. So there is also the scenario that Derbyshire County Council are aware of the changes of the configuration of the junction, and that it doesn't present the problems now that it previously presented in 2018.
So, but thank you. So it's reasonable. You said we don't know the answers to that as to why it is. We know there have been some changes, not the full one-way system. You accept that as well. Now, I don't know whether you had the chance to check it or not.
No. So we can see from the junction itself there have been changes from 2018 to now. Yeah.
So, but still, nevertheless, reasonable to request that to be assessed if you don't know the answers to why it's operating like that now.
Well, reasonable is a subjective comment, really. I mean, I suppose, forgive me, I don't want to be elusive. To answer the question, if Derbyshire County Highways asked us to model the junction, we would have modelled the junction.
Yeah. Okay, and I have your other answers. Thank you, that's helpful. Okay, Mum, I'm conscious I've been going for an hour and 20 minutes. I'm going on to accessibility now. It'll be fairly short, but it maybe 20 or so minutes, 25. I wonder whether the witness or you would like a short break.
I'm easy either way.
I would appreciate one, ma'am. Just a comfort break.
We'll come back at past then, if that suits.
Thank you.
The price onto accessibility next. Could I take you first to your proof again, page 11? Policies relevant to that. You've listed there first of all, PD1, which we see various criteria, but the one that's highlighted, requiring developments are easy to move through and around, incorporating well-integrated parking, pedestrian routes, and where appropriate, cycling routes and facilities. So that's the internal connectivity and external connectivity of the proposal.
That's what I understand, yeah.
There's then a whole host of them under HC19 on 12, on page 12. We have, in particular, one, delivering sustainable patterns of development, so development that's sustainable, including in the sense of being accessible, properly accessible. Yeah.
Sustainable, accessible, yeah.
Hello, that we're here.
Yeah.
Parking the debate about the overlap with that. Then we have 5, requiring facilities are well related to public transport infrastructure and provide high standards of accessibility to all sectors of the community. So to comply with that, we need to have high standards of accessibility for everybody in the community.
That's what it says, yeah.
Yeah, so that would include the fit and the less fit and the able and those who have impairments.
Yes.
Okay, thank you. And, okay, well, there's more of those, but I don't think I need to go through them. In terms of national policy, we see on page 14 the paragraph reference to paragraph 109. Significant development should be focused on locations which are or can be made sustainable through limiting the need to travel and offering a genuine choice of transport modes. So you agree this is a relevant policy? Yep.
So 109 from MPPF?
Yep.
Yeah.
This is a relevant policy, and the test or criterion there is a location which is or can be made sustainable in the first place, and also one which offers a genuine choice of transport modes. Yep.
It does say that.
And by the use of the word genuine, do we agree what that means is something that's not merely theoretical or unrealistic choice, something that's theoretically possible but is unlikely to prove attractive or useful to people? It has to be something that would be genuinely something they might want to use.
Yeah, so we're talking here about reasonable opportunities to travel by sustainable modes.
Okay, thank you. Okay, good. And I think we also agree, Mr. Carey, agree when we're looking at that, we have regard to the guidance. I think you said, and it struck me as actually quite similar to things that Mr. Carey said to me as well, that you don't consider ourselves completely bound by any particular piece of the guidance. They're useful tools to look at. It depends, because you always have to go to the specifics of the case.
Yes.
And you have to consider a number of factors, of which distance is clearly an important factor, agreed? Mm-hmm. But not necessarily the be-all or the end-all.
Correct.
Okay. Because you also need to consider, you said, the quality of the routes, and that can have various aspects, and it can include the difficulty of the routes because of things like gradients.
It can, yes.
Okay, good. So, for example, where that gets us, just dealing with the generalities first before descending into the specifics, is that you might have a site. Well, you gave an example yourself. You gave an example of the bus stop that's across a 4-lane motorway. Mm-hmm. You might be within a recommended or acceptable or maximum distance, mm-hmm. and yet not be genuinely accessible because, for obvious reasons. Mm-hmm. And the contrary can also be true, that because there may be particular reasons to think that although you're beyond a recommended guideline, you are still genuinely accessible for particular reasons.
That's true, yes.
Good. Then, with that in mind, then, can we go to your table at page 30 in your proof, table 2.6? And Can I just note what you say before that? So we have the table, and just above that on page 29, 5.54, where you set out the, did I say 2.6? Sorry, I meant 5.6. I think 2.6 was from your rebuttal. You say in the second line of 5.54, the table demonstrates that the local amenities are within acceptable walking distances, with bus stops being within the distances in guidance produced by the Chartered Institute of Highways and Transportation. Right. Can I just work out what you're saying there, first of all? Are you saying that the local amenities are all within acceptable walking distances, including bus stops? Or are you saying or are you saying something different? As I've read it, you're saying the local amenities are within acceptable walking distances, and including the bus stops.
Correct.
Yeah. And so they're accorded with the guidance produced by the CIHT.
CIHT guidance is one element of assessment.
Okay. So all of the amenities are within CIHT guidance distances.
Sorry, are you looking for, sorry.
So are you is that what you say? Are you saying that the local amenities are within acceptable walking distances, are those set out by the guidance produced by the CIHT?
In the context of this, the bus stops are within CIHT guidance. The other local amenities are within acceptable walking distances.
Okay, so does it follow then that you agree that the local amenities, other than bus stops, which we'll come to separately, you accept they're not within the guidance produced by the guidelines produced by the CIHT?
Some of them may be beyond, or some of them are beyond the guidance, particularly from IHT.
Okay. We have the IHT guidelines set out at your page 32, table 5.7. And we see obviously there's a variety there: town centres, one set; commuting, school and sightseeing, another set; and elsewhere, another set. And I just want to see whether we agree on what the relevant ones are in this case. The town centre guidelines are not the relevant ones because we're not in a town centre. Do you agree? That's talking about developments in town centres.
No, I've always taken that to read as if the town centre is your destination.
Well, I think we may disagree about that. That would seem a bit odd, because it would say anything that's more than 800 metres away from the town centre isn't, or even 400 metres away from the town centre isn't within the acceptable walking distance to the town centre, which would seem a bit peculiar to say people wouldn't walk more than 400 metres to the town centre.
Well, I think therein lies the problems with regards to applying maximum preferred, desirable distances to destinations.
I put to you actually that the answer is you've misinterpreted that, because else in the guidance on it, and I think in the white young green paper, there's reference to the fact that people, when they're going between different amenities in town centres, will want to walk shorter distances. They expect things to be closer when you're in a town centre. So, for example, if I build a block of flats, in the city centre, I will expect to walk less to the supermarket than I would if I lived in the suburbs. That's why you have lower distance in the town centre.
I'm not sure I'd agree with that statement.
Okay, well, I'll make the submissions on that, but that's my position anyway. Well, maybe then we don't agree on this, but because what I was going to put, what the applicable column is the elsewhere column. So when we're looking here, if we're trying to apply the IHT guidelines to this site, a desirable walking distance for amenities would be 400, acceptable would be 800, and preferred maximum would be 1.2 kilometres.
If you take the IHT guidelines as presented in that table there, that's the inference. Okay. However, the context around the text above and below that paragraph, that table, is designed to ultimately contextualise the challenges and perhaps the weaknesses with the IHT guidance and how there are other sources of information with respect to acceptable walking distances.
But let's stick just with applying them and see what results we get for the person. I can understand you want to contextualise it, but let's start with the basic questions. Do they comply with the guidelines or not? And I think whether or not I'm right or you're right about the town centres point, it's perfectly clear, isn't it, that the amenities listed in table 5.6 on page 30 are all beyond acceptable walking distances according to the IHD guidelines.
Depending on the amenity and which point you measure it from, because obviously within this particular site, as we've mentioned, it is a linear site. So what we've presented, and I think Mr. Carey has done a similar task at looking at travel distances from the easternmost access of the site, but then also the westernmost property, and if you had to try and take an average, it would probably be somewhere in the middle between those.
Well, let's go through line by line then. So the bus stop and the school I'm going to park because they're slightly different. We have a separate column in the IHD guidelines for commuting and going to school. We also, I want to deal with bus stops separately as well because for reasons I'll come to. If we look at the rest of them, so restaurant, 1.4 kilometres from the site access, 1.9 kilometres from the westernmost property via Wyston Road. Pharmacy, 1.6 and 2.1. Hospital, 1.6 and 2.1. Possibly again leave hospital aside because that might be a slightly different case. Convenience retail, 1 and 1.5. Cafe, 1.3, 1.8. Bank, 1.3, 1.8. Airfield industrial estate, 1 kilometre and 1.5 kilometres. Again, those are all greater distances than the acceptable guideline in the IHT, because these all must be elsewhere. These must all fall within the elsewhere column, whether it's about the origin or the destination.
From the westernmost part of the site, they do go beyond the IHT recommended maximum.
So even from the eastern, even from the site access, they're all a kilometre or above, so above the 800 acceptable.
Yes.
Okay, so they're basically, some of them, in fact, 2 of them are within the preferred maximum, namely the airfield industrial estate and the convenience retail, but they're still above acceptable according to the IHT guidelines.
According to the IHT.
And obviously, so, thank you. In terms of bus services, there is now more specific, I think there was previously as well as reference against, but there's definitely now more specific guidance from the IHT on how new developments should be located into bus services. We have that core document 510 referenced in Mr. Carey's proof. The bus services and urban developments. That document, so let's say 510, 2018. Do you have that?
I do.
Yeah. When you have it, if you go to page 18, please. Just note a few points. So, under the heading walking distance to bus stops and hubs, the planning and development site should consider walking distance to bus stops and corresponding bus catchment areas. Custom and practice skipping over the next line, custom and practice for many years suggested a maximum walking distance of 400 metres from a bus stop. There are a number of factors, however, that demand a more rigorous approach to catchment area planning. As the 400 metre criteria dates from a time when bus use was less challenged by competition from the car and may not be consistent with the goal of shifting mode share from car to bus. So what that's saying is we may need to have a stricter criterion because people are more tempted to use their cars now.
That's what I inferred.
Second one is acceptability of walking distance isn't a standalone consideration. You've got to consider total journey time. You agreed with that explicitly, I think, in your evidence. People will walk longer to reach bus services that are fast and direct or more frequent. and to stop serving a wider range of destinations. No disagreement with that.
No.
The proportion of elderly people is increasing, so 400 metres may be excessive when slower walking speeds are taken into account. People with children, buggies, heavy shopping and the like, more sensitive to distance. So don't disagree with any of that.
Some bus users are more sensitive to distance.
Yeah. The point I actually just made, acceptable walking distances are lower in town centres than in residential areas.
I think expectations are.
Yeah, people's willingness to walk. The quality of the route itself may affect people's judgment. Safe routes, well overlooked with visual interest, will be less onerous than isolated, poorly lit and uninteresting routes. Do you agree that's a factor?
Quality of the route, yeah.
Okay. And then say, taking all these factors into account, it's recommended that new developments be planned with sufficient compactness and density to enable the maximum walking distances to bus stops in Table 4 to be achieved with viable services. They're intended to enable the bus to compete effectively with the car and benefit a wide range of people with different levels of motivation and walking ability. And it goes on to say, caveat, the distances shouldn't be applied uniformly without regard to the specific characteristics of the location of the route. For example, a shorter maximum distance may be appropriate for hilly terrain or for access to hospitals or older people's residences where the walking environment is unattractive. So that's saying pointing out the topography may reduce the acceptable walking distance.
For some users, yeah.
Yeah. Okay, thank you. And then Table 4, we see various situations. We see for single high-frequency routes, which is defined as every 12 minutes or better, the maximum walking distance is 400. Less frequent routes is 300. And the applicable one then here is 300, isn't it? Because it's an hourly service.
Currently an hourly service, yeah.
Okay. And if we go back to your Table 2.6, it's clear that most of the site is beyond that. It's only properties close to the access that will be within 300 metres.
Based on these distances, yes. I think with regards to that document, if I can just elaborate on that slightly. Again, the points that we've made about selective use of various guidance that are available is applicable in this scenario as well. Having looked at the evolution of that particular IHT document, what perhaps has not been referenced so far is the context in which this is prepared. That context being thrusting towards sustainable urban extensions. So it is principally focusing on the provision of new bus services in areas that are large enough to generate a catchment which is designed and would support new services. I would not necessarily agree that some of the conclusions here in respect of walking distances to bus stops are applicable to the sites such as the one we're considering now, where with the best intentions it would be difficult to encourage a commercial bus operator onto the site.
Yeah, it talks about new development sites, planning of development sites, new developments be planned to enable the maximum distances to be achievable. I accept there is a wider context to the rest of the document, but it's specifically talking here about new developments. Agreed?
It does say that, yeah.
Okay. And in terms of, I don't know the reference to the sustainable urban extension, but this is I know SUE has become a term of art in planning, but this is proposed as an extension to the urban area. It's an extension of the settlement, isn't it? This site.
The definition of that is one that's probably less on me, but it is to the south of Ashbourne, which has been described as an accessible location.
Okay. And okay, there is, I think in your evidence in chief as well, you referred to you said after saying there's a plethora of guidance, we have regard to it, it's useful, but don't always slavishly adhere to it. We judge everything on its merits. You said, but we go back to I go back to Manual for Streets. And Manual for Streets says, as other documents do as well, that walkable neighbourhoods are characterised by a distance of about 800 metres to amenities, doesn't it?
I don't have it in front of me.
I don't think it's Manual for Streets 1. I don't think it is in the inquiry itself. We've got 2. Couldn't find 1, but it is referenced in White Young Green. So if you take up White Young Green,
how far do people walk?
yes, that
Yes.
one. I've forgotten. I know it's you refer to it with the names of the authors. I've referred to White Young Green.
Walkinshaw and Bunn.
Yeah. It's CD. Sorry, I had the reference a moment ago. CD 6.20.
Sorry to interrupt, but could I just ask a very small favour? Mr. Price still has, I think, my hard copy of something. Then could I just get my file back? Thank you. I'm sorry. Oh, was it not? Oh, okay. No, don't worry. Don't worry. Don't worry. Don't worry.
Okay, thank you. So when you have that, if you could go to page, it's paragraph 1.7. I don't think there's page. Oh, there are page numbers. They're very small. Number 4, page 4. You have that, and so that's the reference Manual for Streets. Promoted the concept of walkable neighbourhoods, which are characterised typically by having a range of facilities within 10 minutes walking distance, about 800 metres of residential areas. Applying that, I mean, in fact, you've also referenced the other point because it goes on to say not an upper limit. That was the bit that you rely on. But it starts with, this is the characteristic of a walkable neighbourhood. It has a good range of facilities within 10 minutes walking distance, about 800 metres. And again, from what we just looked at in your table 5.6, we can see that this site doesn't have a range of facilities within that distance.
Within 800 metres, there's not a great deal of choice.
Okay, good. Okay, and just in terms of, and as I said, in terms of looking at the guidance, and I know that you haven't said this, so I wonder whether you would, so I'm grateful that you haven't, but I just want to be clear about it. The White Young Green paper itself isn't official guidance of any kind, is it? It's a paper which reviews the guidance and research.
Yes, it's a research based on empiric evidence that, from what we understand, this is the best thing we have at the moment that collates the range of guidance, both historic and current, that we're examining at the moment, and tries to pull them together to look at what is applicable, what's appropriate, and then contextualise that.
Okay, and it's not being adopted by any professional body, by the CIHT or anybody else, or the government or any official bodies as its own guidance?
Not that I'm aware of.
Okay, thank you. Thank you. Just bear with me 1 second. I'm just going to see whether there were just a couple of questions possibly on travel plan and something else. No, I don't think. Will just bear with me. I'll just check if there's anybody else. Is there anything else? Oh, okay. Yes, sorry. Bear with me. There was one question I was asked. You don't have the document. Well, I'll just put the question to you. I understand if you can get to this. My understanding is that the framework travel plan that was agreed or shown to the 2.1 to the Highway Authority. So you're taking a note.
Apologies.
No, okay.
Thank you.
Yes, the framework travel plan that's been agreed with the Highway Authority, or used as a basis for your consultations with the Highway Authority, didn't have binding targets in relation to modal shift. Is that right?
Pardon?
Doesn't have binding targets in relation to modal shift.
At the moment, it has guided targets to be confirmed upon the occupation of the 50th percent. Well, once the development would be occupied by 50% of the residents or 50% of the units are occupied, detailed travel surveys, that would trigger the need for a detailed travel survey, which would then be used to formulate an accurate baseline of mode split. That would then become the basis for achieving the targets that are set out in the framework.
Yeah, and I think the indicative targets, and we can look at it if you want, are quite modest, aren't they? There is you're looking at a 1% modal shift in, for example, cycle and pedestrian.
What I think we're proposing is actually a 12% mode shift away from car.
Right, I think I'll leave that there. Thank you very much. Thank you, ma'am.
Did you want to re-examine?
I think there might just be one point, ma'am. Just bear with me, because I have to confess, if it's not already completely obvious, that my documents have gotten in a little bit of a state of disarray. No. Just check my tickets. Good afternoon, Mr. Price. A couple of short questions, if I may. Firstly, you were taken through a line of cross-examination about trees and the arboricultural report and the plan and so on and so forth. And then you were asked a question about, well, what if the road has to be widened 5.5 metres? And you answered that in quite a bit of detail about incongruous features with the carriageway to the north, for example. But I just want to ask you this. Are you aware of any evidence from anybody before the inquiry that there is any need for the carriageway to be widened in that location for safety reasons?
There's none.
Secondly, let me just make sure I've got the right one. You were asked a number of questions again about the five-way junction, as we're calling it, the Sturston Road junction. And I just wondered if you could just take up MPPF, please, and turn to paragraph 114D. Have you got that in front of you?
114D, I do.
Yeah. So we know that Mr. Carey's position is that, on his view, there is a moderate adverse impact in this location. Just can you help the inquiry with what in those circumstances, if the inspector preferred Mr. Carey's evidence on that point, then with respect to what 114 says, would it be a reason for refusal, and what would we have to do about it?
So 114D references significant impacts from development on the transport network in terms of capacity and congestion, or any highway safety can be cost effectively mitigated to an acceptable degree. So moderate, to my mind, would not be classified as significant if we were to accept the terminology of moderate impact.
Thank you, Mr. Price. That is all I have for you on re-examination. Thank you, ma'am.
Right, thank you very much. Thank you, Mr. Price.
Thank you. Thank you.
You're free to go. Mr. Lally, then, evidence in chief.
But I was going to ask, could we take, I thought we were having a comfort break, could we have a proper breakfast and we can switch, because I'm going to have to delete a lot of PDFs and reopen them.
Okay, yeah.
Thank you.
Should we come back at 1:45, so 10 minutes?
Yeah, that's fine, thank you. Good afternoon, Mr. Lally.
Good afternoon.
Can I introduce you to the inquiry, please? Your name is Matt Lally. You're a chartered member of the Royal Town Planning Institute, a fellow of the Royal Society of Arts, a non-executive board member, and academician. That is a real tongue twister. At the Academy of Urbanism and Design Council, appointed built environment expert. Is that all correct?
That's correct.
You're a director within the City Planning and Regeneration team at ARA, which, as people will no doubt know, is a major and well-respected multidisciplinary consultancy, and you have a bachelor's degree in town and country planning and a master's in urban design. Is that correct?
That's correct.
You list in your proof a variety of publications on urban planning and design that you have been responsible for. I won't trot through all of those, but just note they're at your 1.4 of your main proof. And you say you've served on numerous design and quality review panels, including being past chair of the London Borough of Barking and Dagenham Design Review Panel, visiting tutor in urban design at University College London, Oxford Brookes, University of Technology Sydney and Belgrade University.
Yes, that's correct.
Thank you very much. You have a summary proof, a main proof and a rebuttal proof. Again, ma'am, if I may, I will take all of those as read largely. And you say you're familiar with the site wider area, local and national planning, local and neighbourhood planning policy, and you also describe the evidence that you give being focused on the reason for refusal, number 5, I think, and that you have visited the site and independently reviewed the planning application to confirm your assessment concurs with the planning authorities. Can I just correct? I think there's one correction in that. I think in your proof you said that the visit was prior to the to your instruction or confirming your instruction. But
Yeah, if you like, there was an online visit using Google Street View, followed by an in situ visit in that order.
Thank you. And you confirm in line with the that your evidence is given in line with your that of your the ethics and professional standards of your professional body, being the RTPI.
Yes.
And that the opinions you express are your own.
Yes.
Professional opinions. Thank you. Okay. Could I ask? The inspector hasn't been to the site yet. You've said various things about it. I think we can actually see it illustrated. We haven't gone to this yet, but the site as it currently is. I'll just ask your view on this. If you go to the design and access statement, which is core document 1.2, and we see, if we start on page 24, section 4 or chapter 4 of the statement, the site, we get a series of photographs from different angles of the appeal site, showing its gradients, undulations, and hilly nature. Sorry, I beg your pardon, ma'am. Yeah, sorry, 1.24, quite right. Apologies.
Page 24.
Page 23, sorry, 24, correct. It's just to give you some picture of the site before we start talking about it and whether the design is appropriate for it or not.
With a brooding sky.
It is, yeah. Whoever took the photos probably just escaped a shower. And if we just trot through those on 24 through 25, 26, 27, through to 29, where we see, I just want to confirm this, what we see peeking out over the top on 29 in the photograph there, is that the houses on
The red row.
the red row
houses,
estate.
yeah, that's
So they're looking down on the
correct.
onto the
They're
motorway.
facing to the
Thank
south.
you.
Yeah.
And that and the wider valley, which we do have some pictures of, is the site's immediate landscape context.
Yes,
Which
and the red rose scheme is probably better seen on page 31 as well.
Okay, I'll look at that. The inspector will, of course, see all of these on site when she goes, but just to give her a flavour of it for the purposes of this evidence. Okay. Can I ask you then to turn back to your proof, pages 5 and 6, where you set out and then summarise the general thrust of national policy. So far it's as relevant, and I've just deleted you. I'm not going to ask you to read all the detail of that, but you bring it all together in paragraph 4.9, so I just wondered if you could read that, where you summarise the effect of national and local planning policy and guidance.
Yeah, I think there's a very clear line of sight between national, the MPPF, the supporting national guidance, the local plan policy and the neighbourhood plan policy that we're particularly concentrating on here. And I just summarise that drawing each of these policies together and the associated design guidance, the required design approach is clear to establish a site-specific, creatively designed layout of buildings, routes and open spaces with a well-integrated design proposition that shapes a characterful neighbourhood as a distinctive and locally appropriate sense of place. Yet, in my opinion, the layout falls short in relation to local context, character and identity in 3 ways, and then I go on to summarise each of those 3 ways: the relationship to the landscape setting, the integration into the surroundings via physical connections to the site context, and the townscape and architectural character.
Thank you. So let's deal first then. So these are the 3 main issues in which you say the layout is, or falls short, as you say, in terms of the objectives of national local policy and guidance. You identify in 4.1 what is said in the SHLA about the site being visible from new development to the north within Spittal Hill and elevated land in the wider landscape, which you say accords with what's in the landscape sensitivity study. And then below that you go on to say it occupies a strategically important location presenting the southernmost face of the town. And at 4.14 that this visually prominent site serves to provide a green buffer enveloping the southern limits of Ashbourne and foregrounds the edge of the town with attractive arid landscape, woodland and agricultural fields. And then say identify what was in the planning officer's report, that the relationship to the landscape character of the wider countryside should form a key component of the site's design. And you say, then go on to say why it doesn't do that. So the final sentence, you say, explain below, in my opinion, the proposals fail to make the site's relationship to both the landscape character of the wider countryside and townscape character of Ashbourne a key component of its design. Now, what I just wanted to do is, because I think actually what then happens is you deal with the second of your issues, which was the...
I can briefly step through each of those if you like.
Just looking at the relationship to landscape setting rather than integration into surroundings via physical connections, which I think we then go on to see. Where do we find the part of your evidence which talks principally about the relationship to landscape setting and what is wrong with that?
Well, there's 4 points that I cite in particular. 4.18 refers to the cul-de-sac approach, which, as you say, relates to physical connections, but I think it has a relevance to the landscape setting as well. 4.22 then generally seeks to highlight the use of standard building types that are used on various other developments, and so really what we're seeing is a copy and paste approach with standard building types. First of all, the highway comes first, is the way that I interpret the sort of the design of the scheme. It's sort of a highway-led approach to design, and then the placement of a series of standard building types. And then in 4.24, I then reference the landscape and character of Derbyshire report prepared by the District Council, which identifies this falling within a specific character area and identifies specific architectural characteristics of that character area, and we can see that those characteristics aren't applied to the townscape treatment. And then 4.28, I make the point about the development turning its back on the adjacent spaces and doing so via a series of close board timber fences in the main.
Okay, on that point, can I dwell on 4.28 onwards for a moment? And what you say there, you say, as you alluded to, it's under the heading generally lack of integration of individual dwellings into the landscape and proliferation of boarded timber fencing treatments. You make the point over the page, the overall impression given is a layout dictated by cul-de-sac highway geometry, and you've just referenced that. So can I just ask, in relation to that, I mean, it's obvious we have a long single road going through here at that point. Why is that harmful or inappropriate in design terms as a response to the landscape setting, in your view?
What I seek to do is identify the, the land draw reference to other reference points that really sort of identify how sort of special the site is, that it has this strategic importance. It's extending around the southern limits of the town. You could say it represents the last southerly edge of the town. It's seen from across the valley, from Wyeston Road, as identified in the Strategic House and Employment Land Availability Assessment, and indeed within the Landscape Sensitivity Study, Map 2 included in that document identifies it as a site of high sensitivity. So we're asked to pay particular attention within the policy to the edge of settlement condition, and for that reason I think it is a site with obviously a very particular topography and one that is deserving of a particularly unique design approach.
Okay, you reference the landscape character and design SBD and what it says about the importance of boundary treatments to integration into landscape setting. Can we take that up, please? It's document 5.4. Do you have that, or do you need to be supplied with it?
Oh, you're cross-referencing.
I'm cross-referencing. You've mentioned it in your proof. I just want to take the inspector to what is actually said there.
Yep.
Okay, it's page 25 within that you've referenced.
I don't have that to hand.
Core document 5.4. Page 25.
Thanks. Thank you. Yep.
Could you just identify the relevant part when you've got that on your laptop, and just if you could, I think it's quite a short passage, but if you could just read out what's said there. About boundary treatment.
Okay, we're in. Apologies. The both paragraphs?
Yes,
Yep.
well, if you just read, I'll tell you where to stop. If
Okay.
that's all right.
The successful integration of new development with its surroundings would largely depend on the treatment of its boundaries. In turn, this must have regard to local landscape character. The design of boundary walls and fences, for instance, should have respect for this, as well as for their prominence within the street scene. Hard edges to development are out of character in many landscapes, particularly where they relate directly to open countryside.
Okay, if you stop there.
Yeah.
Can we then just have a look back at the DAS and see what is actually proposed here? There is, and if you go back, so it's CD 1.24, and it's page 55 within that. There is one of the 3D visualizations. Showing the rear gardens on the downhill portion of the site. I just wondered if you have any comment on that, in connection with what you've said in your proof about boundary treatments.
Yes, and you can see the extent of it if you turn the page 56, sort of see the extent of it extending across the whole development. So one can see in the page 55 image there, the open space is on the right-hand side, on the southerly side of the development, and very much the development is turning its back on that open space, and the open space is entirely characterised by a close board fence.
Okay. And if we could go, I could ask you to turn back in the DAS to page 51. We see there there's, responding to the topography, the most important consideration for the design of the development has been the topography. It has been considered as an opportunity as much as a constraint. And then there's a discussion of key principles. And then, in particular, this feature of the development, the gardens on the southerly side of the road, downhill. It says gardens running uphill will require some retaining features, but have been carefully designed to ensure they're minimised by responding positively to the topography. Do you agree that this is with a suggestion that this is a positive response to the landscape and topography? In terms of the proliferation that you refer to, can we have a look at one of the other plans? You refer to the enclosures plans, which is core document CD 2.5. And if you could just explain what we see here and how it relates to your point.
The enclosures, the enclosures.
Apologies, Mum, you spotted that, yeah. But in fact, it's a bit of a valid point. It's marked as a superseded plan. Can I just check? It's I think the current one is 2.26. So I think if we get to refer to that instead.
Yep. So what we see there is a colour coding of different boundary treatments, and the top two types of treatments. There's sort of a purple dashed line, which is a 2 metre high timber close boarded fence, and a blue dashed line representing a 1.8 high close boarded fence. And then there are a couple of other types of boundary treatment below. And then when we look on the plan, we can see that the vast majority is either that 2 or 1 metre close timber high close boarded fence treatment abutting the open spaces.
Okay, so rather than having these treatments, what is your view on what would have been good design here?
One can almost look out the window, actually. It's really lovely in this part of the world how you see sort of clusters of houses nestled into the valley landscape, and there's that traditional sensitivity as to how the site topography informs the placement of buildings in really a series of quite subtle ways. And we're seeing none of that subtlety. We're seeing that very much it's determined by the highway arrangement. As I say, the standard houses, yes, they face onto the street, but they very much face away from the open space. And traditionally, one sees a whole series of different, walls and lots of hedges and lots of subtlety in the way that can be handled in a much softer and sympathetic way.
Okay. Is there anything you want to say on the question of the integration of the development into the landscape and the layout in particular?
I think all I would say is that it's the image of the Red Row development is quite instructive in terms of where we're heading with for this proposal as things stand. And let me just find the right image.
Is it within the DAS? There are 3D visualizations as well.
Yeah. Sorry. Well, I think one can see on page 9, for instance, the existing photograph of the Red Row development. And else, that's as good as any. Really, that's where we're heading. We're heading for developments, nondescript, anywhere development that turns its back on the adjacent landscape in a very crude way, and that can be seen across the valley, and really it presents a very attractive face to the southern side of the town.
I think some of the properties that we see on page 29 of the DAS at the Red Row do actually face onto the valley. So there's houses that back on, I think, and side on, and the houses that their frontages face the valley. Is there any of that variety within the appeal proposals?
There is some frontage at the far western extremity of the development.
Yep.
Though those are the quad blocks that are referred to, and which are the affordable housing blocks, and actually designed to the lowest level of specification. So yes, there are some developments that do present that frontage, but not a very good one.
Okay. In relation to your other points, in particular about layout, movement, permeability issues, which you've touched on, but we've spent quite a long time discussing those from a highways perspective. I just want to, is there any, so I'm not going to go through the detail of that because many of the points or the underlying facts or factors are similar. Is there anything additional you want to add from an urban design perspective on that issue?
Yeah, I think what hasn't really come out properly is that at the end of the day we're talking about people, and I think PD1 is very clear in these terms, policy PD1 of the local plan, which talks about the importance of socially integrated, high quality, successful places. And it's that social integration that we're now missing, because really what we want to be talking about here is neighbourliness and community building and the ability to have social interaction. But now what we're looking at is very much a socially segregated enclave that doesn't facilitate easy social integration with the neighbouring areas.
Thank you. Okay. There are a number of other points then taken up, for example, in particular 4.30 of your proof, the question of street trees. Mr. Carr, for the appellant, has responded suggesting that there will be adequate placement of street trees in order to be tree-lined in accordance with MPPF. I think it's paragraph 136 now, or 135, it's moved. Do you have any further comment on that?
I would just reiterate the comment that I've made in paragraph 4.30, and I cite the particular document number that shows the plan that shows the placement of trees, and how it's not really what one would regard as a tree-lined street. There are sporadic placement of trees placed generally in the private curtilage of individual dwellings, rather than a tree-lined street in the traditional sense of the word.
Okay. Thank you very much. I don't have any further questions, but again, is there anything that I've not covered that you would like to add before it is your time to be questioned, although that may not happen today?
No, I don't think so. Thank you.
Okay, thank you very much.
I just had one question. You say in your proof at paragraph 4.13 that the approach from Wyerston Road from the south was a key historic entry point. I just wondered if you could elaborate on that for me.
Excuse me. It's the only route that is coming from due south, and is a long-standing route. I don't know how long it's been there. I would hazard that it may be medieval in origin, but it's certainly a very long-standing route. It's a public highway, and one can see the southerly face of the town from that location.
Okay, thank you. Ms. Ogley, we're going to cross-examine tomorrow. Is that still the case?
Yes, please, ma'am. I will certainly be more than 45 minutes, so it'll definitely take us over 5 p.m. So yes, I think that probably makes sense, given the early start.
And the evidence in chief for Mr. Carr, you've got that at 1.5 hours. Is that still the case?
Now, I think we may well be able to be a little bit faster than that. I suspect we'll be probably in the realms of 40 minutes to an hour.
Okay.
I will do everything I can to speed it along as quickly as possible. I mean, you know, ultimately you can obviously read the design evidence for yourself and form a view. But nevertheless, I think there are some key points that do need to be dealt with in cross of Mr. Lally. But yeah, we will be as swift as we can.
Yeah, I think with evidence in chief, assuming everything's been read, which it has, that would be helpful if we could, just because I've got a long journey tomorrow to get home. Okay. All right, okay.
We'll decide what we'll do with Mr. Jackson, I suppose, because you need to know whether to come or not to come.
I sent a timetable.
Oh, I'm sorry,
Did you
Mum,
receive
I've
it?
seen it.
I think I've moved him right back.
Right, so.
as a sort of after housing land supply, and with ecology as a sort of, I don't want to say mopping up, but you know what I mean, things that are less contentious towards the end. I just put them on the end because we had space this week.
Yep.
Would that suit?
I was just asking for just something he didn't get forgotten, he turns up tomorrow.
If you could let him know.
Mum, if I may, I've spoken to Mr Jackson, so he knows of the change, and it's fine.
Okay, have a look at that timetable and let me know if it looks all right overnight, and any concerns, let me know in the morning.
Thank you.
Okay, coming back at 9:30 then tomorrow. Yeah.
Yeah, fine for me, Mum.
Lovely. All right, I'll see you at 9:30.